30 seconds.
My bad. I heard Jason say,
Yeah.
here we
My
go.
apologies.
Call the meeting to order. Roll call. Dennis Bender.
Here.
Here we
My
go.
apologies.
Call the meeting to order. I already did.
You
Mhm.
did.
Roll call. Dennis Bender,
Here.
Maria Okpara,
Yeah.
yes. Rick Raleigh,
Here.
Wilson Sell.
Yeah.
Will you please stand for the Pledge of Allegiance, and Mr. Bender, will you lead us in that?
Yes, I will. Pledge allegiance to the
The
flag
flag
Of
of the United States of America
and
and to the republic for which it stands, one nation,
under
under God, indivisible, with liberty and justice for all.
It's time for the oath of office. Mr. Bender, will you please rise?
Alewa.
Can we have all of the board members also rise alongside like we would if we were out in the big room? Thank you.
Mr. Bender, will you raise your right hand, please? Will you, and repeat after me? I, Dennis K. Bender,
I, Dennis K. Bender,
do solemnly swear
do solemnly swear
that I will support and defend the Constitution of the United States
that I will support and defend the Constitution of the United States
and the Constitution of the State of California against all enemies,
and the Constitution of the State of California against all enemies,
foreign or domestic,
foreign or domestic,
that I will bear true faith and allegiance to the Constitution of the United States
that I will bear true faith and allegiance to the Constitution of the United States
and the Constitution of the State of California.
and the Constitution of the State of California.
And I take this obligation freely
And I take this obligation freely
without any mental reservation
without any mental reservations
or purpose of evasion,
or purpose of evasion,
that I will well and faithfully discharge the duties upon which I'm about to enter.
and that I will well and faithfully discharge the duties upon which I am about to enter.
Thank you so much,
Thank
Thank
you, Maria.
Bender.
Yeah, that was good.
Mrs. Blasingame, will you please raise your right hand? And repeat after me. I, Adeline Blasingame,
I, Adeline Blassingame,
do solemnly swear
do solemnly swear
that I will support and defend the Constitution of the United States
that I will support and defend the Constitution of the United States
and the Constitution of the State of California against all enemies,
and the Constitution of the State of California against all enemies,
foreign or domestic,
foreign or domestic,
that I will bear true faith
that I will bear true faith
and allegiance to the Constitution of the United States
and allegiance to the Constitution of the United States
and the Constitution of the State of California.
and the Constitution of the State of California.
And I take this obligation freely
And I take this obligation freely
without any mental reservation or purpose of evasion,
without any mental reservation or purpose of evasion,
and that I will well and faithfully discharge the duties upon which I am about to enter.
and that I will well and faithfully discharge the duties upon which I am about to enter.
Welcome to the club, Ms. Blasingame.
Thank you.
And now, annual organization. In accordance with Educational Code Section 5017, 35143, and 72000C2A, requiring governing boards hold an annual organizational meeting within 15 days commencing with and including the second Friday in December. from December 11th to December 25th, to elect a president of the board, clerk of the board, the name of a trustee, and an alternate who will serve as a representative at the annual meeting of school and community college district representatives, and determine dates of regularly scheduled board meetings for the coming year.
Maria, I would nominate you as the president since you serve the clerk. And then I will ask Rick to serve as the clerk of the board.
I second that.
I second that.
Oh, Dennis is second already.
Okay. All in favor?
Aye.
Any opposed? Okay. So who's going to be the representative?
I nominate Wilson.
This is so. I second that. How about the alternate,
Dennis,
I'd like,
Mr. Bender?
Okay.
Who's seconding that?
I'll second that motion.
Okay. And the meeting schedule?
the county meetings are just basically, they will announce it. Usually there's a general meeting February, and then there's a special, but the district will receive the announcements.
Okay. So we'll go when the county gives us their calendar.
Yeah.
You will need to take a vote as well on the representative and alternate.
Yeah.
And the current meeting schedule was attached in the agenda for the proposed meetings for the 21 and 22 school year board meetings. So that was part of our packet.
I move the item to, I'm sorry, I move the item to approve the alternate representative. Oh, we need one motion for representative, alternate, and meeting schedule.
That's
So
you can do
that'll
that.
be my motion to move the item for the representative, which would be Wilson So, alternate Dennis Bender, and the meeting schedule as proposed in the agenda.
I second it.
All in favor?
Aye.
Any opposed? Okay. Now we're going to go into a presentation.
You're going to take a quick break so that Kylie can go distribute, or I can, the closed session potential readouts to the clerk, and allow for any family members, if they have not yet left, to leave so that we are official to go into closed session. So we will take a quick break.
Yeah.
And no business will take place while those papers are delivered.
Thank you.
Thank you.
Thank you.
Where can I get the cheese?
You can come here.
We don't want to join breakout rooms yet, correct?
No, that's going to be after the presentation.
Correct.
Yeah, but I want the cheese. Where is it?
I think people are leaving to it.
Yeah, we'll fix it. Sorry. We'll fix it. I think Jason didn't know the breakout schedule.
Actually, in order to, I put everyone in the breakout room so we don't hear you having conversation while we distribute the paper, and then I can close it and then reopen it, if that makes sense. So I just need to know when to reopen.
Are we just about ready? We can give them a 1 minute warning, but it takes about 1 minute to close those rooms. So should we
Okay.
go ahead and start that process? Oh, they're coming back. Okay.
Everyone should be back.
Mrs. Okpara, you can, couple things. We've got to go back and check with Kylie about public comments to make sure we don't have any, or we do. And then we can go to our presentation, B1 on page 2.
Are we back on?
We're ready, yes.
Kylie, do we have any public comments?
We do not have any public comments at this time.
Thank you. Now we are going to go into presentation on B1.
Mrs. Chidester? You are muted.
Okay.
Sorry.
I apologize. Good
No.
afternoon, board members, superintendent, cabinet. I'm going to try my best to keep this to half an hour to help us all brush up on our important obligations under California's open meeting law, which is often referred to as the Ralph M. Brown Act. And to the next slide. The courts have given us a great deal of guidance in interpreting the Brown Act, and the public also takes it very, very seriously, and members of the public often spend a good deal of time monitoring school board agendas, city council agendas, and other local agency agendas to avail themselves of information about the business of the public entity. And if we're not careful and we're not cautious, it's easy to make a mistake that can not only be embarrassing to the public entity, but it could wind the public entity up in litigation. So it's something to take very seriously. Next slide, please. The purpose of the Ralph M. Brown Act is to provide access to government agencies' business and to prohibit secret decisions. It's to require actions and deliberations of boards to be taken openly and subject to the public's scrutiny. Next slide. One of the most important things to remember about the Brown Act, and this applies to both open and closed session items, is what is a meeting? Before the coronavirus, most of us thought of a school board meeting as something you had to attend physically. Obviously, that has at least temporarily changed, and we're going to talk briefly about the governor's orders. But the definition of a meeting is much more than people getting together in one place physically. It's any congregation of a majority of the members of a legislative body at the same time and location, including teleconference location, to hear, discuss, deliberate, or take action on any subject within your jurisdiction. So, of course, in our case, a majority of 5 is 3 members. So if 3 members outside of a duly noticed agendized meeting compare their views on a subject within the board's jurisdiction, that's a meeting. It's also an illegal meeting because it hasn't been agendized for the public and the public doesn't have access. Next slide, please. So what is a meeting? 20, 30 years ago, we didn't tend to think of text messaging as being a meeting. But for example, if Mr. Raleigh were to send a text message to Mr. So, and then Mr. So were to listen to Mr. Raleigh's views and add his own and forward that to Ms. Opara, that's a direct communication. If it's outside of a duly noticed meeting, that's an illegal communication. And it is something that the district can have legal liability for. So the Brown Act says a majority of members shall not, outside of a meeting, use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, forgive me, or take action. So for example, if Mrs. Nelson were to call up 3 members of the board and say, next time we're going to vote on this, what do you think about it? How do you think you'll vote on it? Those members aren't talking to each other, but Mrs. Nelson, if she did that, and she would never do that, but if she did, she would be acting as an intermediary. And again, outside of a notice meeting, that's absolutely illegal. We're going to talk in just a moment about there's only one time that you can poll the board, and that has to do with bargaining. Next slide. So here's a caveat. And again, this is where we all have to be super careful. This shall not be construed as preventing an employee or official of a local agency from engaging in separate communications outside of a meeting authorized by this chapter to answer questions regarding a matter within the subject matter jurisdiction. If, and that's a big if, the person does not communicate to members of the legislative body the comments or position of other members. So back to the example, and Trinae, thank you for letting me pick on you. Back to this example. Trinae can speak with each of you outside of a meeting to answer questions, but she can't say, and oh, Mr. So, by the way, Mr. Raleigh said this. That would be illegal because she would be communicating another member's position. So ask questions, and that's one of the reasons why you will often hear when you take a Brown Act workshop, please don't reply all, because when you reply all, you may be communicating your position. Next slide. So even if members conferring outside of a meeting didn't intend, they didn't mean to come up with a collective concurrence, if there's a resulting determination outside of a notice meeting, how the board's going to vote, then whether you intended it or not, that's an illegal meeting. Next slide. And of course, all meetings of the board must be open, public, except an authorized closed session. Next slide. Action must be taken by the board in an open session unless a closed session is authorized. And look how broad this definition of action is. It's a collective decision, a collective commitment, or a promise by a majority of the board to make a positive or negative decision or an actual vote. Next slide. And these were the rules for teleconferencing pre-pandemic. Posted at all locations. Every location has to be listed in the agenda, and every teleconference location must be accessible to the public. And I can't tell you how many times there's been a client district that we work with where there's been a very dedicated board member who just has surgery. They're in the hospital and they want to participate in the board meeting by telephone until they find out that their hospital room has to be open to the public technically under this rule. So, but anyway, again, these rules have been modified. Let's look at the next slide. Teleconferencing, all votes have to be by roll call. A quorum has to participate physically from a location within the district. It must still be conducted in a way that protects the statutory and constitutional rights of the public. And we'll go to the next slide. So last March, the governor issued 3 executive orders, temporarily suspending some of the rules of the Brown Act. Next slide. So, meeting by Zoom, of course, physical appearances of members are presently not required. Notice of each location is not required. The location, our example of the member in the hospital bed, the location does not have to be accessible to the public, and agendas don't have to be posted at all the locations. Next slide, please. Oh, I'm sorry. No requirement that a quorum of members have to be in the district. Serial or simultaneous updates are allowed if there's a declared emergency. Members of the legislative body may ask questions during updates, and that may be without public access. But again, members may not discuss among themselves nor take action on updates because they're not on the agenda. Next slide. So this is a little tricky. When is a meeting not a meeting? This is not in the Brown Act. This is in the bargaining law, the Educational Employment Relations Act. A meeting and our negotiating discussion with the exclusive representative of the employee unit does not have to be agendized. A meeting with a mediator or negotiating parties does not have to be agendized. A hearing, a meeting, or investigation by a fact finder does not have to be agendized. And so you're probably asking, well, why do we always put it on our agenda in that case? We put it on the agenda because, quite frankly, it's important for the public to know what's going on in the closed session, that you are going to give instruction, for example, to Dustin and his negotiating team about your parameters. So even though under the Educational Employment Relations Act, technically you don't have to put it on the agenda, we always recommend that you do. And at any point, if you have questions, please jump right in. Next slide. So this provision is so old that they use the old term executive session, which is what they used to call closed sessions in 1976 when the bargaining law was enacted. An executive session of a public school employer or between the public school employer and its designated representatives for purposes of discussing its position regarding any matter within the scope of representation. So typically that is your closed session when you decide what authority you're going to give to the district's negotiating team. Next slide. You may, in case of what the Brown Act calls a dire emergency, hold a meeting on an hour notice if you notify all media when there's a threatened disruption of public facilities. A closed session would require a 2/3 vote to hold, and all special meeting requirements apply except the 24-hour notice. Minutes in the notice persons and organizations have to be posted for 10 days afterward. Next slide. So I promised to talk about closed session, and it only took me 18 slides to get there. The board may meet in closed session only for authorized reasons. The board must agendize and disclose the items to be discussed in the closed session. And that's why Trinae and Kylie are always so meticulous about specifying on your agenda the limitations of the closed session so the public knows the topics you'll be discussing. And only those matters agendized may be discussed. So you can't get a bright idea that's not within the agenda item and spring it on your fellow board members in closed session. It has to be on the agenda. Next slide. Following the closed session, when you go back into open, you must disclose any final action that was taken and what the vote was. And if the vote was not unanimous, you have to specify how each member voted. Next slide. If the board's considering suspension or discipline of a student, the matter is heard in the closed session, but then you come out into open session and take the action. Next slide. Also, the board has to notify, and of course you would do this through your superintendent and her cabinet. The board must notify the student and the parent or guardian that the student will be discussed in the closed session, and the student or the parent can request that you have the discussion in open session if they do so within 48 hours. And of course, that very seldom happens. Next slide. Again, any final expulsion action must be taken in open session, and names are not used, student numbers are substituted. Next slide. I think we missed one. There we go. So if you are giving your negotiator instructions about a real property transaction, a piece of land that the district is going to buy or sell, the board has to identify in open session who its negotiators are and the people that they may negotiate with. And then once the transaction is approved, the board is required to disclose all of the terms. Next slide. Closed session for either existing or anticipated litigation. And that's when you receive advice from legal counsel. And anticipated litigation is when your position may be prejudiced, the board's position may be prejudiced if it is not discussed in closed rather than open. And litigation doesn't have to be filed in the Superior Court. It could be, for example, a PERB unfair labor practice case. It could be a special education, Office of Administrative Hearings matter. All of those fall under litigation. Next slide. When you're considering existing litigation and you give your attorney in that matter approval to defend, to seek appellate review, or to represent you as amicus in an existing action, you have to identify the adverse parties and what the subject of the litigation is. And that's often done by case number. Next slide, please. Existing litigation has been formally initiated. Anticipated litigation, based on the facts and circumstances, the board believes there's significant exposure to litigation. And facts and circumstances could be a tort claim or a threat to sue the district, where the facts are known to the district, but perhaps not to the potential other party. Next slide. In the case of beginning litigation or intervening, the board isn't required to discuss the particulars, but it must disclose its decision to initiate litigation, unless it would jeopardize serving the other party with the lawsuit. And approval of a settlement of existing litigation sometimes is not immediately reported directly after the closed session, and that's because the settlement might not be final. Once it's final, it has to be reported at the very next meeting in an open session. Next slide. So this is one that I'm sure you see on every agenda: to consider appointment, employment, evaluation of performance, discipline, dismissal, or release of an employee. You also would use this government code section to consider complaints or charges about an employee. Next slide. When you're going to consider specific charges against an employee, the government code says that your superintendent and her cabinet must give the employee 24 hours advance written notice of the employee's right to have the matter heard in an open session. You still get to make your decision in closed, but the employee can request that it be heard in open. And when this section was first enacted, I believe it was around 1994, people didn't really understand what it meant. So subsequently there was litigation, and the court said, for example, if you're going to not reelect a probationary teacher, you don't have to give advance notice. That's not a specific complaint or charge. Next slide. It's also not required that you give a teacher that you are intending to dismiss notice. And the reason for that, the court in the Coulter case said, is because when a teacher who is permanent, when you initiate dismissal charges, that's a very long process, and it is filled with a great deal of due process steps. So the court said you're only initiating it, you're not taking a final action. Next slide. So personnel matters, action taken that affects the employment status of an employee. You must identify the title of the position. So for example, if you're going to release a site administrator, you would say the board took action in closed session on motion of Ms. Opara, seconded by Mr. So, to release a site administrator at the end of the school year. Next slide. Closed session salaries. Closed session with the designated representative regarding salary and fringe benefits of employees. The board must identify its designated representatives in an open session. Trenae and before her Tom Hogerman are always very meticulous about this. Years ago, superintendents would go into closed session with the board and they'd negotiate their own salary. This section absolutely prohibits that. That's why the board identifies one or two members as its negotiator or representative to negotiate salary with the superintendent outside of a closed session. Next slide, please. Closed session shall not include final action on the proposed compensation of a unrepresented employee. And that's why you can't vote on the superintendent's contract in closed. You can discuss it, but the final vote must be in open session. So closed sessions, EERA, Educational Employment Relations Act matters are exempt from the Brown Act, as we said earlier. So if the district was going to have a meeting with the union, that is exempt from Brown Act requirements. Same thing, a meeting with a mediator is exempt. Hearings or investigations or fact-finding are exempt from the Brown Act, and closed session between the board and its negotiators are exempt from the Brown Act. And that last bullet, ladies and gentlemen, that's why if you tell the superintendent it's all right to poll you outside of a meeting about negotiations. Let's say AVUSD and the district have been meeting and they're very, very close, and all that's holding up an agreement is 0.25% of salary. The superintendent may lawfully, if you allow her to poll you, call you outside of a noticed meeting to see whether you wish to give that authority for that additional 0.25%. But that's the only time she can poll you, is if it's related to negotiations. Otherwise, she can't do it. Next slide. The board must publicly report any action in closed and the vote or abstention, and that report can be made orally or in writing. And if the board approves any documents or settlement agreements in closed session, those must be provided to the public upon request once they're final. Next slide. Closed sessions do, you may keep minutes of closed session. We don't recommend it, and the other law firms that do what we do typically don't recommend it. Your record of closed session is the action that you publicly report out. And the reason for not doing a minute book, the reason it's not recommended is you want to be able to be completely candid and honest with each other in closed. Next slide. This, I believe, is what Mr. So was speaking about when he talked about the county superintendent and Brown Act training. A person may not disclose confidential information that they received by being in a closed session unless the board authorizes disclosure. And it is a misdemeanor, ladies and gentlemen, to disclose closed session information without the express permission of the board. I will never forget the day many, many years ago. I was a much younger new school lawyer then. On a Wednesday night, I attended a closed session of a governing board, and the board gave parameters to our negotiating team. The next morning, I showed up at the negotiation site, and we began meeting with the teachers union. And before I could open my mouth, the teachers negotiator told me what my offer was going to be. And that person could only have known because a board member violated this particular prohibition on disclosing closed session information. So important to the integrity of your decision-making process. Next slide. Unauthorized disclosure of closed session could prejudice your position as a district in litigation. It definitely undermines your administration's efforts to manage personnel matters, and it destroys the confidentiality of closed session. So very harmful to have unauthorized disclosures. Next slide. Confidential information is any communication made in closed that is specifically related to the basis for the meeting. Next slide. Here's some of the penalties. Here's the trouble we could get into if anyone discloses closed session information. A member of the public could seek an injunction from a court to order the individual who violated closed session not to do that. The matter could get referred to the grand jury if it is believed that a member of the board or an employee willfully disclosed closed session information. And neither of those look good for the district. Next slide. An employee who unlawfully discloses could be the subject of disciplinary action if they have training about closed session requirements. Next slide. There are very, very narrow limits on that prohibition. The member could seek an opinion as to whether the action in closed session was lawfully taken, or a complaint to a district attorney or a grand jury if the person believes that the body violated the law in closed session. But those are the very narrow exceptions to non-disclosure. Next slide, please. There are very, very limited disclosures under whistleblower statutes that may be protected. Again, that's typically when the individual believes, rightfully so, that the board violated the law in closed session. Next slide. So this is the potential punishment that all of us risk if we disclose closed session information. As Mr. So said earlier in the meeting, every member who attends a meeting where a violation of the Brown Act occurs who intended to deprive the public of information it was entitled to is guilty of a misdemeanor. So literally, it's a crime. Next slide, please. And again, to prevent a violation, a member of the public can seek an injunction. They can file a writ of mandate against the district to stop or to prevent violations, or to determine whether penalizing or discouraging the expression of a member was invalid. Next slide. This happened to, this has now been many, many years, probably over 20 years, but a remedy that a court can order if a district violates closed session. This happened to Capistrano Unified School District in South Orange County. The court ordered that the board had to record its closed sessions and had to file those recordings with the court. Next slide. So sometimes we make honest mistakes because the Brown Act can be highly technical. The remedy for that is a member of the public, if they believe that our district has done something incorrect or unlawful under the Brown Act, can file a written demand that the board correct the action that was taken in open session. They have 30 days to do that. If they believe that the board took an illegal action in closed session, they have 90 days to do that. And over the years, some of our clients from time to time have received cure or correct demands. Normally, when that happens, our advice to the client is, yes, you did, no, you didn't, depending on the facts, violate closed session or violate the Brown Act. But let's not spend money on lawyers. Let's just put the action on the next agenda properly and take the action again. And that cures or corrects the alleged violation, and you don't spend money litigating whether you were right or not. Next slide, please. So again, the board has to be given a chance to cure or correct the alleged violation, and that's the reason you would retake the action, re-agendize it, and take it again at the next meeting. And you want to do that because you don't want to pay even my reasonable attorney's fees, and you don't want to pay the attorney's fees of the other party that's bringing the action against you. So that's why we cure or correct. Next slide, please. So the district attorney or any interested person can sue the school board for an alleged violation. Many years ago, there was a gentleman who was a professor at Pasadena City College. His name was Richard McKee. He was an expert in the Brown Act, and he used to follow, this is in the days before the internet, so they were harder to come by, but he used to look at the agendas of school boards and city councils, and he would often find mistakes, Brown Act mistakes, and he would usually contact the district and threaten to get the district attorney involved. So you can see the cure or correct method is very powerful. Next slide, please. So related to the cure or correct action is a cease and desist letter. And there's a longer period of time, that's up to 9 months after the district violated the Brown Act. The board has 30 days to respond, and you have to promise never, 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 never to do it again. Next slide. So in the cure or correct, you're not admitting you did anything wrong, but the correction has to be in an open session as a separate item of business. And you must promise to notify 30 days in advance of any unconditional commitment being rescinded. And this is very, very rare. I don't know why the legislature thought it was necessary, because we already had cure or correct. And you very seldom see this section used. Next slide, please. So I'm doing all the talking. Here's a hypothetical for you. Let's pretend that a superintendency is vacant and one of the site principals has applied for the position, and the site principal is good friends with a school board member. So after the meeting, the principal calls her friend, the school board member, and says, "Have I been selected for a final interview?" What does the board member answer?
Sorry, no can do.
No can do. Can't talk to you about that. Sorry. Next slide. So a school board member is the CSEA chief negotiator in the district next door. And the district is involved in fairly contentious negotiations with its CSEA unit. And so the board gives direction to its negotiators in closed session. The day after the closed session, the board member shares the district's confidential strategy with his CSEA bargaining team in the district next door. Did he violate the Brown Act?
Yeah.
Yeah, absolutely.
Disclose the closed session.
Absolutely. Next slide, please. So the agenda contains a closed session to consider an expulsion of a middle school student for selling drugs. The student's dad happens to own the local business that employs a board member. Dad calls the board member into his office, his employee, and he wants to discuss the evidence that's going to be presented to the board in closed session concerning the expulsion. Yep, I see Mrs. Blassingame shaking her head. Can't do that. Absolutely not. Next slide. Well, thank you for listening to my long rant. Comments or questions or complaints?
That was very informative. It is a technical, there's a lot of moving parts to the Brown Act.
Absolutely.
Good
Yeah.
job, Maggie.
Yeah.
Well, thank you all. It's lovely to see you. And if I don't see you,
If I may jump in on one comment. As I said, I've been involved with the board member training at the request of Dr. Herb Fisher, many years back. And there's a frequent question that came up at sometime at the very first session and sometime after the discussion of Brown Act. My point is that if a member of any board or any council, I say knowing that he or she has committed a violation and don't do anything about it. I say if the violation is serious enough, that member should resign from the board. And so my question will be, what are we going? If something happened in this town, should we do anything about it?
so is the question, if you know that there's been a violation of the Brown Act?
Not just the Brown Act, but a lot more serious. Yeah.
Well, you are representative of the public. The public elected you to follow the education code and the Constitution and the laws of the state of California.
Sure.
So if it's within your jurisdiction, if it's within the jurisdiction of the school board, then there's very likely a public expectation that you would correct the problem.
Right. And I'm glad you make that a response. And I will make a comment about a few years back. I knew that a city council member accepted a bribe from the contractor because city council member came to me and said, Wilson award this contract without any bidding. I cannot do that as a public works director and city engineer. I refused it and I disclosed it publicly. So this member requests me to award a contract. And the member later on had to resign from that council. I just wanted to point it out.
Very serious.
Yes, that's bribery.
Thank you so much, Ms. Maggie.
My pleasure. I wish you all a very peaceful and safe holiday.
Thank you, Maggie.
Maggie.
Good luck against Oregon.
We'll need it, Mr. Bender. Thank you, sir.
Okay, now we're going to take a brief break and then go to closed session.
Let's take a break, yeah.
Kylie, are you still there?
Can you see me? I'm still here, yes.
I think she went to the breakout room. Kylie, I'll go and ask her what she wants. She may want cheese. Do we have any cheese anyplace?
I think down in the kitchen.
So
Jason, are we still streaming? It looks like I see the live on custom streaming.
Yes, we cannot cut the stream or else we'll have to restart the entire thing.
Understood.
I will know when to end the break.
Okay, I'm gonna just verify once everyone's back in their seats. And that way we can come back in before we go into closed session to take a motion for closed.
I moved you to the break so you can verify, then I'll close it.
Are we all in?
No.
Not yet.
Matt might have been, oh, there he is. Perfect.
Okay, now we are going to continue with our board meeting. At this time, we are going into closed session. Will you read everything on that we're going to discuss?
Yes. So item 1, public employee discipline, dismissal, release, reassignment, transfer, leave, title certificated and classified employees. Number 2, public employee, appoint, resignation, retirement, reduction, title, certified and classified employees. Number 3, conference of litigation, government code section 5495.9, subsection A, current litigation, 5 cases, CIVDS 1813952, CIVDS 1907172, CIVDS 1937043, CIVDS 2011183, CIVDS 202956, Government Code Section 54954.5, subsection C, and 54956.9, subsection D. Number 2, and E1, it's anticipated litigation, 4 cases, 208/1907, 209/2007, 2020-21-01, 220/21/05. Number 4, conference with labor negotiator, agency negotiator Dustin Conrad, employee organization Alpha Valley Unified Teachers Association. Number 5, conference with labor negotiator, agency negotiator Dustin Conrad, employee organization California School Employees Association. I will ask now for a motion to go into closed session. Do I have a motion?
So
We go to close.
Okay, we have a motion by Blassingame, second by Bender.
All in favor?
aye.
Aye.
Any opposed? Okay, 5-0.
Okay.
You'll need to join the breakout room for closed session.
You see it? Did anything pop up for you, Dennis? That shows, there you go.
Are we all in?
We're waiting for Kylie. We're all here.
Okay. Calling the meeting to order. Kylie, do we have any reports from CSEA?
We do.
Okay.
Hello, distinguished board members, Superintendent Nelson, and Cabinet. I hope all of you are in good health, safe, and ready for the break. Another year has come and gone. We as leaders have endured many changes. Those changes have changed the landscape of our lives. I can tell you that the time that I have had these last 2 years spending with our classified staff has been truly and it was a great honor and rewarding. I would like to thank all the school board for your dedication to the students and recognizing the important role our staff plays in its operations. With the district's leadership, CSEA was afforded the opportunity to share with our staff viewpoints and cooperatively come to an understanding in which enriched the lives of our coworkers. More than ever, I feel we are striving for a balance never seen before. Thank you. I think a side effect of all of this is better employees, better attention to students and coworkers' cooperation. My time as a speaker for the chapter has now been handed to a new president. I wanted to let you know I feel confident the new leadership will increase the cooperation to new heights. Kim Calvin, the new incoming president starting on January 1st, 2021. Many of you will recognize this name. She has always been intelligent, confident, and passionate toward the protection of employee rights. This time, with all of her experience and the support of eBoard, she will be able to enlighten even the sky. Our Vice President, Carl Willis, in his second year, is very charismatic and passionately cares about the classified, students, and community. Our new second Vice President, Nick Garrett, brings an alternative view to our leadership team. It is his knowledge, confidence, and great sense of leadership that will help us keep going forward. Treasurer Jonathan Silva is an eBoard officer who held a previous position in our team and has decided to broaden his horizons by taking on this new role. He is well liked, but has had a hurdle. He is a hugger, and this pandemic has hampered him. As a chief job steward, he prides himself in finding solutions in the following policies and procedures. Political Action Coordinator Joshua Verholtz spends many waking moments trying to keep up the chapter up to date on what's in the political arena to share, promote, and inspire and support our legislation for our students, community, and school district. Our chapter relations officer, Susan Josso, is a person who has been in our leadership team for quite some time. She is a promoter of our causes and our future. Secretary Shelley Ames, who does our clerical, keeps up to date on our communications, and without her, the president would never leave the office. I feel confident that this group of leaders will be the example with President Kim Calvin leading the team, that the district will continue to see positive outcomes, solution opportunities, and the satisfaction we help the students, community, and coworkers to be their best. I want to wish you all the best holiday time and spirit of hope. Stay safe, healthy, and pray for the less fortunate. God bless. Mike Kaufman, CSEA Chapter 828 President.
Thank you very much. Thank you, Mike. And do you have any reports from Apple Valley Unified Teachers Association?
I do not.
Okay. Closed session reports.
Yes.
Clerk will read out any action taken in closed session.
Yeah, thank you, Madam President. So the board approved unanimously the memorandum of understanding with the California School Employees Association 828 dated November 13, 2020 regarding prescribed work hours at Mariana Academy, ratified on December 10th, 2020. The board also unanimously approved the memorandum of understanding with the California School Employees Association, Chapter 828, dated November 13, 2020, regarding the impacts and effect of COVID-19 conditions for the 2019-2020 school year closure, ratified on December 10th, 2020. The board unanimously approved the memorandum of understanding with the California School Employees Association, Chapter 828, dated November 13, 2020, regarding the Aetna Air for the 2021 school year, ratified on December 10th, 2020. And finally, the board approved unanimously the memorandum of understanding with the California School Employees Association, Chapter 828, dated November 13, 2020, regarding the addendum to return impacts of the effects of on CSEA bargaining unit with Apple Valley Unified School District, ratified on December 10th, 2020. And that's all I have to report out from closed session.
Thank you very much. The board may approve the agenda as is or add and or pull items from the consent agenda for discussion and or action. We need to adopt the agenda as is. And I need a motion.
Motion that we adopt the agenda as is.
Second.
All in favor?
Aye.
Aye.
Any opposed? Well, we have public comments. Kylie, do we have any public comments?
We do not have any public comments at this time.
Thank you. Superintendent's comments?
I just want to congratulate Mr. Kaufman on the last 2 years as CSEA president. His term, as he has indicated, is coming to an end, and Kim Calvin will be taking the reins back. What he spoke about is who he is. He always is trying to uphold others and talk about how brilliant they are, and never focuses on himself. And so I just want to take this time right now to say how proud we were to work with him, and the collaboration that he created with the district was very much appreciated. And so as he leaves, we did recognize him in our staff newsletter yesterday that went out because he has done a wonderful job for the past 2 years. So congratulations, Mr. Kaufman, on finishing a 2-year presidency with CSEA. We look forward to seeing you around just doing what you normally would be doing, which is our HVAC. So is that correct, Matt? That is correct. And then I would like to congratulate Mr. Bender for being reelected in Area 3. We appreciate, as I said last time, when Mrs. Davis was retiring, service. And the fact that you ran again tells us that you're here to support the kids in this community. And I really appreciate that, as I do know the community does as well. And then we'd like to welcome aboard Mrs. Blassingame as the new trustee representing Area 1. And I think you'll learn very quickly that this team is very much collaborative and focused on students. And so we're excited to have you aboard. And then I will have further comments at the end of the board meeting. Thank you.
Thank you. Okay, now board comments. Mrs. Blassingame.
Just like to say, I'm very grateful to all the voters who placed me here, and I hope they will put their trust in me and to do the right thing. And I want to say happy holidays to everyone, as much as you can be happy during this time of the year.
Thank you. Mr. So.
Mr. So, I think you're muted.
Go next door and wake him up.
You're next, Mr. Bender.
Can you hear me now?
Yes, we can hear you now. Go ahead.
Just wish everybody a safe, happy holiday. Yeah.
Mr. Bender?
No, I just want everybody to have a good break and enjoy your families. Thank you.
Mr. Raleigh?
Yes, I got lots of congratulations to do here. First off, for Maria as board president, we really look forward to your leadership. You did a great job as the clerk, and so I know you're going to do very good as president of the board. So looking forward to the next year. And then I'd like to congratulate Dennis again. It's, I'm kind of dating myself here because it was 45 years ago that I was roaming the halls of Apple Valley High School as a Sun Devil. And Dennis was, yeah, I don't know I think he was pretty young back then as a teacher. So I'm going to congratulate him again for after all those years of teaching, then he's stepping into as a school board member, really dedicated his life to teaching. And then again, I'd like to congratulate Adeline Blassingame. I know you have a long history of teaching in the high desert, and we really look forward to working with you and the rest of the board in the coming year. Thank you.
Well, very nice.
Time for my comment. I'd like to use this time to congratulate Mr. Kaufman for a great job. I found him to be very humble in the discharge of his duties. I particularly enjoyed all of his statements towards the board when he comes up and taking the time to personally meet with each one of us when the board meeting was in person. I also like to congratulate Mr. Bender. Another year. I really enjoy working with you, and I hope you have a pleasant time this year around. Mrs. Blassingame, I don't know where to begin except to say welcome aboard, and I'm grateful that you joined this team, and you'll find out very quickly how much we work together. And then the rest of the cabinet, I have to say, I have thoroughly enjoyed this school year and the challenges that you all have faced and how you have had to address each one of those challenges, even if it means to work overtime, extra days, weekends, you name it, you have made it so seamless for us as we come in. And I have to say too, that this is the first board meeting that we have held with very little glitches. And I really have to say, thank you for what you have done. And then as we leave for the Christmas vacation, I'm hoping that everybody will have a good time. But as we also have a good time, let us think of those families that are hurting at this time. Because we have quite a few of them, even within our school family, that are hurting. I send my sincere sympathy to those families, and I tell you that we are here to lock arms and hold you all up. Happy holidays to all of you. Okay, there is no public hearing. Discussion action session. It is recommended that the Board of Trustees discuss and take action on the following items. Approve the requested leaves as noted.
Make a motion, we approve.
Second.
All in favor?
All right.
Aye.
Any opposed? Consent item. It is recommended that the Board of Trustees consider approving a number of agenda items as a consent list. Consent items are routine in nature and can be enacted in one motion without further discussion. This procedure conserves meeting time for a full discussion of significant issues. Consent items to be approved in one motion are 1 through 5.
Make a motion, we approve items 1 through 5.
Second.
Go ahead.
All in favor?
Aye.
Any opposed? Okay. Kylie, do we have any public comments?
We do not.
Okay, thank you. Superintendent comments.
So I'd like direction from the board to go ahead and agendize a special meeting for January 7th at 1 p.m. We'll do it again virtually. And the topics would be the governance team and some norming as well as negotiations. We will continue to look into Good Beginnings, which is a CSBA offered training for our board. I probably will have more information regarding that and trying to get a schedule set at that board meeting as long as you all give me direction to do so. Would that be feasible for everyone?
I don't see a problem. Does anybody see a problem?
No problem.
Okay, Kylie will get the information out to you, just solidifying January 7th, 1 p.m. And again, because it's a special board meeting, we will post 24 hours or 72 hours in advance because topic-wise, we can do a 24-hour, but we can post that Monday just like we have because we know we're going to do it. The second thing is that yesterday we did send out a staff newsletter. We are very much focused on, after meeting with some high school teachers a week or so ago from both high schools, they asked that we focus our attention coming back from the winter break around social emotional learning for our students and re-engaging them and looking at some of those needs that the kids are having. We know that none of us anticipated this long haul for virtual learning, nor did we anticipate the numbers rising the way they did. And so we want to continue to give our teachers permission to work towards that. Focus down on the standards and not try to cover everything that they might have covered within their classroom, but be very succinct about what they can cover and get to some mastery with students. We will continue to focus on our seniors and any of the kids that are struggling to get their credits for graduation. And then within that same newsletter, we focused on the concept of hope. And I feel like the statement that Mrs. Okpara made about this family, this school district is a family. Families sometimes disagree, but we are a family. And as we focus on hope, the picture that we posted into the newsletter was hope is the only thing stronger than fear. And if we can keep driving that forward, that we are hopeful that we will have students back in seat as soon as possible, I look forward to that day very soon. And then finally, obviously, wishing everybody a peaceful and safe break. I hope people get some time to relax. I hope they follow some of the guidelines so that we don't have the spike in numbers that we had after our Thanksgiving gatherings that occurred. And we do want to support our local community in the fact that we are out of ICU beds and out of hospital beds, as everybody saw in the national news last night. I do know the first round of vaccinations came to the hospital today. I got a picture of that sent to me by the CEO, and I just pray for all those people that are frontline every single day with this. So thank you.
Trinae, can I ask you where do the teachers stand in line as far as receiving the vaccine? I know there's different levels of people that are going to get it. Are they going to be getting it quickly?
Yeah, stage 2. So stage 1 is all medical workers. So what you're seeing right now is the frontline medical workers, first responders, and then all of the people that are being cared for in assisted living locations, because they've noticed that the spread obviously is so much greater there because of the close confines. Teachers and school employees as the considered essential are in stage 2. The last update I had looked like early March as the soonest that they would get that vaccine available to schools. So we'll keep you posted as we hear more information.
I'd like to point out they just approved Moderna's vaccine today.
Yeah, that'll help us because that'll give us 2.
And my daughter, I was telling you, she got her vaccination 2 days ago. She's a clinical psychologist at the Veterans Hospital in New Orleans. So they are taking care of the frontliners.
And an alumni of Apple Valley Unified School District.
Better believe it.
Yes.
Which is it, believe it. Okay. Mrs. Blassingame, do you have additional comments?
No,
Thank you. Mr. So?
No, my two youngest are frontline doctors, so they got vaccinated too. Okay.
Good. Mr. Bender?
Yes, I want to give a shout out to Mr. Kaufman, Mike. I appreciate the last 2 years that he served. I forgot to mention that.
Thank you. Mr. Raleigh?
Yeah, same with me. Mike has been a pleasure, and I always look forward to his little presentations that he gave. Very professional. And wish him luck.
Good. And my last comment is, I hope you guys will make time tonight at 7 p.m. to listen to Apple Valley High School and Sandia Academy. Our students do a musical presentation. I am really looking forward to it. There's so much that our students are still doing in spite of what is happening. So I'm hoping that you all can log in and at least applaud your students. That's all I have. Do we need to go into closed session again? Kylie, do we have papers to sign?
There are papers to sign, and there are a few documents that require more than one signature. So it might take me a little bit to make my rounds.
Okay.
But if you could just hang tight for me, I'll come by.
Can we adjourn the meeting and then do the signing?
Yes.
Okay.
Adjourn.
Who's moving to adjourn?
Raleigh.
And who's second? Okay, thank you. Meeting adjourned.
We need a vote.
All in favor?
Aye.
Any opposed? Thank you. Meeting adjourned.